Welcome to our video series called Industry Viewpoints, brought to you by the American Bankruptcy Institute. Each segment will feature an expert providing views on the current state of a particular industry with focus on what lies ahead. My guest on this edition is Lydia Webb from the Dallas office of Gray, Reed and McGraw. Lydia represents debtors, creditors, and committees in major Chapter 11 cases. Here at ABI's Winter Leadership Conference in Palm Springs, California, Lydia was one of the experts on a very popular panel dealing with third-party releases, one of the hottest topics in bankruptcy circles these days. Now, Lydia, I'm so pleased you're here, because I have had an abiding question for years. And here's what it is. The Fifth Circuit has been the most prominent of the, I guess it's 3 circuits, that have precluded Chapter 11 plans from having non-consensual third-party releases. Fifth Circuit's adamant about it. Yet, and this is what I don't understand, the preeminent, most popular venue for major Chapter 11 cases is in the Fifth Circuit. It's Houston, Texas, where you can't have plans that are popular in Delaware and New York. Now tell me, Lydia, with the Fifth Circuit's adamant opposition to these non-consensual releases, how is it that Houston is so popular for big Chapter 11s?
Well, Bill, because I don't think you actually need a non-consensual third-party release to have a successful reorganization in a sophisticated Chapter 11.
So how do you pull it off?
Well, we do consensual third-party releases down in the Fifth Circuit. And I think that in 99 out of 100 cases, that's all you need in order to implement the kind of restructuring that you need in these complicated, sophisticated cases. And so we do it via an opt-out. We do it and we make sure that there's consideration and that there are consent attached to these releases. And that's what you need. That's all you need. You don't have to go the non-consensual
route. How do you get
route.
Consent?
Well, it's a factually intensive inquiry, but if you know what you need going into it, it's pretty easy to lay the foundation for consent. You need consideration. You need a finding that it's integral to the implementation of the plan, which I think that any practitioner would be able to tell you that a third-party release of key constituents in a restructuring is going to be integral to its implication. You've got to have notice. And really, if you can check those couple of boxes and you provide parties with the opportunity to opt out of the release.
And that's in microprint or something, or what?
No, we put it in bold, we put it in caps. No, it's all very above board.
Yeah.
But the reality of the situation is for the parties that have been awake and have been actively participating in the case, if they have claims that they want to opt out of a release, they're going to know when they're going to opt out of that release. For the vast majority of constituents that the restructuring isn't going to really impact, they may not even have claims to release against these third parties, it's not really going to make a big impact at the end of the day. Not every case is a Purdue Pharma.
I see. So when you dangle them some consideration they know they're going to get, that turns out to be enough, huh?
I mean, we have the way that case law is developed down in the Southern District is even if you show that the releases are mutual, that's sufficient consideration to support a third-party release. So again, I may not have any claims against you, but if I'm releasing those claims, there's value there.
Yeah. Well, you know, there was this remarkable decision from the Fifth Circuit just a little over a month ago, I guess, in the, what was the name of the case? Highland Capital. And tell me, Lydia, that case from the Fifth Circuit dealt with what they called gatekeeping. And after that opinion allowing gatekeeping, do you really even need third-party releases anymore?
I don't think so, Bill. I think that, the Fifth Circuit, they were bound by their prior precedent in Zale and in Pacific Lumber to find that 524E precludes, in that case it was an exculpation in Highland. But the same goes for non-consensual third-party releases. That they run afoul of the, you can't release a non-debtor under 524E of the code. But you don't even need to get there if the debtors put a gatekeeping provision
tell us,
in there.
what can you, or how can you structure these gatekeeping provisions that the Fifth Circuit has now blessed?
Sure. Really, all that it matters is that you set forth who are the parties that are going to be impacted by these gatekeeping parties. They're 9 times out of 10 going to be the same parties that would be receiving the third-party release.
I presume it must be pretty much all creditors in the case. Is that right?
That are entitled to the gatekeeping function?
No, I mean covered by it.
Oh, covered by it.
Yes.
Right. It's all of your normal parties and interests that are otherwise going to be bound by the plan.
Yeah, okay.
They are going to be stuck with this gatekeeping provision.
And then who can it protect?
It would protect the parties that are typically going to be asking for a third-party release.
Now, in the Fifth Circuit, can these people protected by gatekeeping be more numerous or broader than those who would receive third-party releases?
I think potentially. I think that the Fifth Circuit opened the gate wide to the potential list of parties that could receive the benefit of having the Bankruptcy Court act as a gatekeeper for future litigation that may relate to actions that arose as part of the bankruptcy.
Okay, so then how does this gatekeeping provision help these people who are being protected? What protection does it give them?
Absolutely. Well, it requires litigants to bring their claims to the Bankruptcy Court first for a determination.
Really?
For a determination of whether they're colorful.
So you can't run out and sue a director or somebody in state court?
Correct.
Oh.
Right.
Well, that sounds like a release in disguise.
I mean, especially if you're appearing before a bankruptcy court that has lived with the underlying bankruptcy case. So yeah, you're coming back to a court that has the underlying knowledge of the facts. They have the knowledge of the parties, and that they are going to be very competent to make a decision of, is this something that falls within, one, something that I have jurisdiction over, and that gets rid of the whole, Purdue jurisdiction issue that they're wrangling with at the Second Circuit right now. But they're going to be able to make a determination of, is this something that otherwise, is covered by the plan or other prior orders of this bankruptcy court.
Okay, so let's say, all right, there is a colorable claim here, and this creditor wants to bring it against a director or somebody. What next? The bankruptcy judge says, okay, well, this is a good claim. Does the bankruptcy judge now have to send it back to state court?
No.
Really? No.
The Fifth Circuit said it's basically a presumption that the bankruptcy court is the exclusive is the exclusive venue to hear these claims that have been brought to the court via the gatekeeping provision.
Oh my goodness. So you got to go to the bankruptcy court. The bankruptcy court, I guess, if the bankruptcy judge, in this case, Stacey Jernigan, were to say, no, this is not a good claim, you're dead then, is that right?
I mean, I can't speak for Judge Jernigan, but I think it would be DOA.
Yeah, okay, right. All right, so if it is a colorable claim, then the bankruptcy judge is the one who's going to rule on it. So you can't get away from the bankruptcy judge. Lord have mercy. That is, I got to tell you, the counsel and the judges in Delaware and New York should have dreamed it up. Because had they dreamed that up, they might have been able to resurrect some of their own market share.
Bill, everything's bigger in Texas,
Well, Lydia, I think those final words summed it all up. It's bigger in Texas, and Lord of mercy, it suggests to me that your courts down there are going to be even more popular than they all are already.
Let's hope.
And I got to tell you, I thank you very much for your insights. Third-party releases, of course, will be the topic of almost every upcoming ABI conference. Take a look at the calendar of events on the website, abi.org, and you'll see a list of our upcoming conferences. And we thank you in the audience for tuning in. The Industry Viewpoints series in upcoming days and weeks will have us talking with other experts about the future of industries that are affected by our turbulent economic times. Until then, be well, stay safe, and good day.